myself, Bill Smith. I've got Felicity Foy, who was a commissioner, and Alan Watson on my right-hand side. So you're appearing on behalf of Benson Farm Limited and Setar 36 Limited, is that correct?
That's correct.
Right, we're open to you then. Fire away.
Thank you very much, Chair. Yes, just to confirm, appearing on behalf of Benson Farm Limited and Setar 36. Both are landowners with large rural land holdings in the Bay of Islands. My evidence today is limited just to those rules relating to helicopter landing areas, specifically Rule R7 and its associated standard S5. To confirm, I support the general direction of changes that have been recommended in the report from Peter Ibbotson. However, my evidence essentially sets out the various what I consider drafting errors in the appended provisions, which my evidence seeks to correct, and that's to ensure that the recommendations of Mr. Ibbotson are properly carried through. So, just in quick summary, the submission points from the submitters on this topic were the same, and sought that firstly, that noise rule R7, which relates to helicopter landing areas, as drafted, only provided for flight movements from emergency purposes such as medical emergencies, etc. And an or was needed to be added to the rule to link to the standards and allow other forms of helicopter movements. Secondly, the standard S4 didn't actually specify what noise standard needed to be complied with. It just referred to the following noise limits without specifying what they were. And then lastly, the definition in relation to helicopter landing areas, and throughout the rule there seemed to be a disconnect between the title of the rule, which applied to helicopter landing areas, and the content of the rule, which applied to movements and landing of helicopters as opposed to the areas per se. So just to confirm, I note and agree with the conclusions of Mr. Ibbotson's report in relation to this topic, that helicopter noise rule and associated standards in the proposed plan are not fit for purpose as drafted and must be revised. Secondly, that I agree with Mr. Ibbotson that a or should be added to the rule, so that only one clause and not both needs to be met in order to be a permitted activity. Thirdly, that there is a lack of specificity as to what constitutes a helicopter landing area, and I agree with the recommended changes as set out, that be included in a definition. So then turning to the specific drafting changes and correction of errors that I've set out in my evidence from page 4 onwards, and I just wondered where the best way to just quickly step through those would be to share my screen, if that's possible.
Yes.
Yep. Yeah, by all means, yep. Mr. Watson's looking at it online as well, but
okay.
We've got the track copies here, Peter.
Well, you can go through it anyway, Peter.
Okay, well, I'll just go through it anyway because it helps me to go through it this way too, if that's okay. So noise rule R7, the first change I recommended there was a simple one to delete the stray reference to PER, or permitted activity 2, because that no longer applies. And just to confirm that my drafting here is in the red text, and that's on top of the section 42A revisions, which are the black strikeouts. So my strikeouts and amendments are in the red text on top of the 42A in the black changes. So the first one is just a simple administrative error, I think, to delete PER2 because there's no longer PER2. Throughout, my next one is throughout the changes to consistently refer to helicopter landing area rather than helicopter landing sites, as I've located there, and that really is just to ensure consistency with what is now a defined term, or proposed to be a defined term, being a helicopter landing area. The next one, and similar to that, is replace the words that helicopter landing site complies with to noise generated from the operation of helicopters using the helicopter landing area complies with. And that's just makes the point that it's not the helicopter landing area per se that makes the noise, it's the activity, the operation of helicopters associated with that. So again, just a drafting improvement in my view. That then probably comes to the main change which I am seeking in my evidence, and that's to include a restricted discretionary step or standard within the rule. And what this is, and I haven't numbered that, I've simply called it noise restricted discretionary XX, because that needs to be formatted into the plan ultimately. But the noise standard S4, as recommended in the Section 42A report, stated there are matters of discretion, and those were specified as being restricted to. And those matters of discretion restricted to, firstly, that compliance with a noise limit of helicopter noise limit of 50 dBA LDN will occur at noise sensitive activities. So that, to my view, is rather than a standard, is a matter of discretion, and as a matter of discretion, in my view, needs its own restricted discretionary activity rule. So I suppose the construct of the rule, therefore, as a result, is that there is a permitted activity step, and then for noise up to beyond the permitted activity step and up to the 50 dBA LDN noise limit would be a restricted discretionary activity, subject to matters of discretion, which I've simply, as you can see, I've drafted in there and simply picked up from the those which were recommended as matters of discretion in previously in the standard. So and I've just pulled out a recommendation or a conclusion of Mr. Ibbetson's report there that the noise limits are intentionally set at low level, and these are the permitted noise limits. I mean, this does not mean that helicopter noise is required to comply with these limits to be reasonable, and that applications for helicopter activity that exceed the permitted standard may be entirely reasonable. For this reason, a 50 dBA noise threshold was given as in the matters of discretion, along with the other matters of discretion which the council should consider when any helicopter noise application is made. So again, my drafting simply picks up those recommendations and converts what are matters of discretion in a standard into an actual discretionary activity step within the drafting. And then as a consequence to that, in the next part, which is now turning to standard S4, simply deletes those matters which were previously in the standard. And as you can see, my deletion at the top there is matters of discretion restricted to. It says now says not applicable, and I've moved these matters of discretion from down here to my new restricted discretionary activity rule. So that really is the sum of the changes which I'm recommending in my evidence presented. I'm happy to take any questions on that.
Are those standards 1994 or 1999?
Those standards are 1994. The helicopter noise NZ S66807 94.
Is that correct, Mr. Ibbetson?
Yes.
Thank you very much. You got any questions? No. No. Is there any point of clarification for the officer, Mr. Baxter, or do you want to comment on anything at this stage? You don't have to, I'm just asking.
So that's additional restricted discretionary? Is that like a rule that you're suggesting, like an additional restricted discretionary rule or standard?
Yes, it is. It's an additional restricted discretionary activity rule which would sit above as the next threshold up from the permitted activity standard. Yes. And as I say, I sort of anticipated that was the intention of the drafting as recommended, which referred to matters of discretion within the standard. In my view, those, if that's the case, that should actually sit as a standalone restricted discretionary activity rule.
Any more? Okay. Davidson, have you got anything that you've heard that you would like in regard to your evidence that you presented?
I'm sorry, I didn't quite get that one. Excuse
I'll
me.
just ask Mr. Davidson if he's got anything you'd like to clarify in regards to the evidence he's put before us that you were referring to, Mr. Hall, sorry.
So there's nothing in particular that's particularly concerning. In fact, many of the things that Mr. Hall has suggested are, I believe, improvements to
Right.
the wording of the rule. If I understand it correctly, the new RDIS provision, which has been numbered yet, is essentially, as Mr. Hall said, next step up, which requires that you meet a certain noise level in order to not be considered fully discretionary. So if I understand it correctly, that RDIS is saying that if you meet the requirements of New Zealand Standard 6807 1994, or the guidelines that are within that it's considered a restricted discretionary activity, and the matters of discretion are in the third column of that table. Is that correct? Am I correct in that? If it complies with the second column, that the matters of discretion are restricted to those listed in the third column.
I can answer that. Yes, that's exactly it. So the matters of the restricted discretionary rule, as it were, is in the second column, are subject to complying with those. Then the matters of discretion are in the third column. That's the sort of standard sort of plan format. And yeah, the other point about that is, therefore, it follows if you don't meet the standards restricted discretionary activity rule, then you default to a full discretionary activity. So in short, anything helicopter noise limit noise above 50 dB LDN 7-day would then default to a full discretionary activity.
But isn't there a confusion there somewhere in the headings? Because that third column's headed up discretionary activity. Then it talks about matters of discretion being restricted. Is that the point you're making?
So, yes, maybe I could go through my views, and it might be helpful in informing.
Well, just have a look at the heading first of all. Is the heading incorrect there where it's got discretionary activity, Mr. Hall? What page is that? Page 5, I think, of your alterations at the top of the third column. It's got a heading discretionary activity. Is that a mistake? Could that be RDA?
I'll just catch up with that.
Okay.
Mr. Chair, I think there's just
We'll just get to what his intention is. But it says evidence.
So the new noise rule is headed noise RDIS, which is the National Planning Standard Code for restricted discretionary. So the intention, as is all zones. So I think that the intention is that it's a restricted discretionary. In the third column there, activity stays where compliance is not achieved with restricted discretionary activity rule, then it becomes a discretionary activity. That's the trigger that I referred to earlier that requires a full discretionary consent.
Okay. So I think it's the heading there, which is separate, and underneath, after you got LDSXX, you've got the heading discretionary activity, and I think that's possibly misleading us. And
Okay.
others. So you're saying that it should flow on from that XXX?
Yeah, there's just a bit of a confusion there, Mr. Hall, because you're talking about restricted discretionary activity and matters of discretion being restricted to. The words discretionary activity almost need to be a follow-on from that table, perhaps. That, if compliance with the if it doesn't in compliance with being an RDA, then it becomes a full discretionary activity, because you normally wouldn't have discretionary activity with matters of discretion being restricted underneath it. There's a mix of terminology there.
No, just to clarify my answer on that in the third column, I think if I'm sharing my screen now, activity status where compliance is not achieved with restricted discretionary activity, then colon is a discretionary activity. That's the sort of format of the plan. So that discretionary activity, there's not a heading there. It's an activity status where compliance is not achieved with the restricted discretionary activity.
Okay.
And therefore, what follows from that is that matters of discretion are restricted to. Again, that's just the format of the plan which I'm adopting there.
Okay, and we can, if we decide to adopt it, we can correct the word and that, hopefully that we understand and other people will understand. Not what I'm saying you. There's a bit of misunderstanding at the moment that needs to be corrected.
Okay.
Mr. Do you want to?
Yeah, look, I think if you probably had a look at, it's just a slight difference in the way the plan is set out. It's only a minor difference that I think is confusing. So I'm looking here, for example, at signs rule 3, where we've got a restricted discretionary rule, and then we've got a separate column separated in that third column, the next one down, that refers to when compliance is not achieved with the requirements of the restricted discretionary rule. So it's yeah, I think the evidence is I think we get the idea. I think it's just moving that down to the bottom of the rule to fit the template. It's just a minor template issue, I think.
Okay. Any other points of clarification?
I think I will make this point. It may be helpful just in understanding how helicopters noise should be managed, and my experience with Waiheke, which was a significant long-term planning, I guess, issue that the public is concerned about. The intention of this rule, and in broad terms, Mr. Hall has synthesized this into it, and I think I agree that subject to some changes to improve the clarification of how that flows through restricted or permitted restricted discretionary, it would be good. But the intention is to have a very stringent noise rule, which is permitted. Then to have a restricted discretionary activity up to noise levels which are up to the upper limit of noise that are acceptable in residential and rural zones, but they should be subject to further restrictions potentially, i.e. annual restrictions, other matters that council can consider. For the Auckland Unitary, or for the Hauraki Gold plan change, there was a restricted discretionary activity up to 50 decibels LDN, but there isn't a lot of teeth to that. Council don't have a lot of opportunity. They take it as much as they can. They don't really have a mandate to require people to limit the number of movements they do per year. So that's what I've tried to do here. In terms of a fully discretionary activity, which breaches New Zealand Standard 6807, I don't believe that should generally be granted. And so, but I don't think that a prohibited activity status is appropriate, because there may be circumstances in which it could be appropriate. But I would expect that most consultants, including myself, wouldn't support an activity or activity that breaches 6807 regularly, like on a daily basis.
Yeah.
So as long as the rule follows that general framework, then I'm comfortable.
So why have it as a discretionary activity? Why not have that default as a non-complying activity?
That might be a little bit outside of my wheelhouse. That non-complying activity would be subject to section 104 of the RMA and required to go through a gateway test. Am I correct? And that would mean that it would have to either be in accordance with the objectives and policies or have a no more than minor effect. So it wouldn't have a no more than minor effect, probably.
Yeah.
Unless there were some significant caveats to that. For instance, maybe someone was proposing to fly in once per year. That might have an effect. So potentially non-complying could I don't know, but maybe it's more of a planning question that you will.
You answered pretty well.
You did. You become a planner. Anything else, Mr. Hall?
No, just to confirm, picking up on the discussion earlier, I think you understand the intent of my drafting. Yeah. So happy for that to be modified to follow through that intent into a format that fits the rest of the plan.
Okay, thank you very much for your evidence.
Thank you.
Thank you. We'll see you later on, probably in other hearings.
No doubt. Thank you very much.
Enjoy the rest of the day.
Thank you.
Now we're going to the Northern Regional Helicopter. Got Carl Taylor, is it?
Yep.
And is Mr. Matheson online or is?
No, he's not coming. He's in Wellington. I just found out. So it's just me. I'm sorry.
No, that's the best thing.
I apologise. I've been a little bit set up for fail here. So I'll do my best to answer your questions, and
We won't give you a hard time.
that's good. Thank you. Appreciate it.
We would if Mr. Matheson was here.
Yeah, I just phoned him. He's in Wellington, so he's not coming. That's for sure. The purpose of our appearance today is really just to ensure that emergency helicopters are catered for within these noise restrictions, really, and we want to ensure that that we basically insert a rule that allows emergency helicopters to be unrestrained, really, in their movements, and obviously for obvious reasons, which is predominantly to save lives and to deal with emergency situations. And secondly, we also feel that we need the restraints lifted to a large extent for some of our training purposes as well. Because if we can't train, we can't then attend missions either. We'd also like to make some minor refinements as well to and that includes just the definitions. That includes helicopter. So that just a bullet point here: helicopters that are in operation for emergency purposes such as medical emergencies and search and rescue facilities, and also firefighting, which doesn't pertain directly to us firefighting, but it still is important for emergency services. Other helicopter operations such as landings, departures, hover, overflights, and taxiing is always also really important that we have the ability to do that as well as part of training and ongoing training for our pilots especially. And the last one is just to make sure that we have the necessary facilities basically for training, and most of that would be sort of around that Kerikeri airfield. And just for some, just for a little bit more sort of insight, so we do approximately 250 pre-hospital jobs in the far north. And all those jobs are normally status 1 or 2 patients. And bearing in mind that when we bring our crews into this area, we're bringing a very high level of care, and it's often high level of care that isn't available from the ambulance service or from the fire service or any other sort of medical centre that's around. And secondly, we do approximately 100 training flights sort of around the far north region as well, which is also really important, like I said, to our ongoing, I guess, maintaining our service really. That's kind of it.
Okay. Can I ask you, have you got some notes there?
I do have some notes.
Is there any chance you could email them?
Yeah, no problem at all.
If you don't mind, and
Yep.
then she will email them to us and put them on site, and then
Yeah.
it makes our job a bit easier. We can reread them.
Yep.
Right, any questions?
There's just one. I mean, I don't know if you've seen the amendments that the planning officers have suggested. That certainly picks up on emergency helicopter operation.
Yeah.
But it doesn't pick up on training.
Yes.
I just wondered whether.
That's what something we're quite concerned about.
Yeah.
Yeah.
Okay.
And-
Any comment from the officers on that at all, or do we not have the appropriate people here?
Kenton is the reporting officer on noise, aren't you?
Yeah, that's right. Yeah, we hadn't considered the training side of it in the section.
These notes I'll send you through. I'll be your email. Oh, whose email? Shall we get?
Me.
It'll be yours, yeah.
Yeah.
That'll have this bullet points that I just sort of pointed out, but just stressing it is super important and it's something that's quite frequently overlooked. But if we can't train, we just can't keep our pilots currently can't fly. So it's really sort of important as part of the service that we provide here.
I just have one question about how this interrelates with the hospitals chapter of our plan. It was brought up in that chapter as well. And just to query staff about how that overlap has been addressed with the helicopters landing at the hospitals, and facilities on that side. I know it's been clear in terms of number 10, but I also wasn't sure how it's addressed within that hospital specific.
Well, if I can just give you from our records,
Hospital check.
just in relation to hospitals from our records within Northern Region, and it's including the Auckland base as well, which predominantly sort of looks after the flying of and hospital transfers. So in Barb Islands Hospital, we had 31 jobs in 12 months. Kaitaia, 91, so a lot of Kaitaia. And that's the key data, so 91 and 31, so just over 100 missions from those hospitals.
Yeah, I worked with Mr. Baxter extensively on this aspect of the submission about the tool training being within scope, but we'll go back and we'll look at that. Otherwise, it would have been something that we would have considered. Mr. Baxter and I will review and have a look at it. Similarly, it may be that 10 is broad enough that it may cover training activities. It is the operation.
Training for emergencies.
Training for
Right. As I say, look, through the chair, as I say, if we have scope, we have scope. But I would potentially argue that a reasonable interpretation of note 10 would be to include those matters, but we can have a closer look at that submission. And I would suggest that 10 also covers operation at those particular hospitals identified in our hospital zones as well.
So what happened, just so you know, the process is obviously we listen from you and then the staff take on board what you're saying and then they report back to us in a few weeks' time.
Yeah.
And that what they come back to us will go on the council's website and you'll be able to see it and you do they get notified, the submitters of it? Yeah,
Yes.
you will get notified that the officers' replies come to us and that will go down on the website. You get the opportunity to read that, but you don't have any further input into our decision. But then we read that, take on board what you've said, A today plus any exhibitions, and then we make a decision. And we don't always accept what the officers say. We might tweak it, we might say no, we don't want that, or we might say yes, we want this as well.
Yeah.
So that's you've heard the question and training for emergency.
Yeah. It's like I said, it's super important to us. Obviously, we I think the other one point to stress is that we do it in the most appropriate manner as possible. So we just don't make a point of flying around people's houses and making a menace of ourselves. We do it as discreetly as possible, and we do it at a time.
Fuel either.
What's that, sorry?
You're not going to waste fuel either.
Absolutely not. No, they wouldn't fly me up here, put it that way.
Anything else?
I have some questions, a few questions, just in regard to the training, if that's possible.
Yep.
So I'm just wondering how, firstly, preface this by Rule 10 says emergency helicopter operation associated with Bay of Islands Railway or Kaitaia Hospital. That's clear. Or any other emergency helicopter operation that occurs from an established helicopter base. Doesn't say helicopter activity associated with an emergency, it says any other helicopter activity. So I would interpret that as training, but you may take a different interpretation.
Okay, thank you.
I think training is important to make as exclusion. My question though is how much of the training occurs at airports and how much of the training occurs away from airports?
The answer to that is we'll try and isolate most of our training to airports, and that'd be Kirikiri mostly. If we do train away from airports, which is not infrequent, we'll make sure it's a very isolated area, and it's normally for our winching and that search and rescue stuff. But again, it's not in the sort of remote areas. It's all kind of very isolated and out of the way, and obviously we need permissions as well going through that training.
So would you not train your pilots to fly these to the hospitals?
Yeah, we have ongoing IFR, which is instrument flight rules training and that kind of stuff, which is kind of fly from point to point, I guess. So there's that part of the training, but the other important part of our training is the winch training. So it's our pilots and our crews holding a hopper and inserting winch medics and that down. And there's certain amount of currencies that need to be maintained with pilots, paramedics, and the winch operators to ensure that we maintain a really high standard. Yeah. As you can imagine, we don't go and do that stuff every day in operations, fortunately.
Yeah.
So we need to sort of do additional stuff on top of just our operational work to make sure that we're at a very high standard.
I had one supplementary question about the submission says not just medical emergencies, it also second part says search and rescue and firefighting purposes.
Yes.
I don't see that being covered under this, and I guess that's a question to the staff about those two other aspects and how they're covered or not, because they won't be based from the hospital necessarily, or are unlikely to be based from a hospital.
So 10 is intended to cover that.
10.
Yeah.
Yeah. Rule 10 is what you're saying. Covers it.
Note 10.
Note 10.
Note 10.
So just highlight stuff that I don't think that currently covered with the current wording. I mistake.
Just for some clarity, there's very few, I don't think there's probably one or two emergency helicopter bases that are located with the hospital in New Zealand. It's certainly not the case in Northland at all.
So you're Kensington, isn't it?
Yeah, Kensington, moving out to Taranaki at some point. And
I wasn't going to say on your own.
no, that's, and then in Auckland, we're out at Ardmore Airport. But yeah, we're not located now. I think Hamilton is the only base, top of my head, I can think of that's actually located right next to the hospital.
Nothing else? Nothing else from anybody?
Just, sorry, the airport has a set of noise contours around it, which does not include, as far as I know, does not include training. It would be ideal for training not to be included in the noise contours, to be excluded from compliance with that aspect as well. I'm just something that occurred to me now. I'm not sure if that is flowed through. That training essentially is excluded from everything, including the airport. So perhaps I'll talk to staff about that.
Okay. We'll let the staff come back with a response. Say that'll be a few weeks' time. What date's that? 4 weeks' time, sorry. And that'll go on the website. You'll be notified what the response is. Then we'll take notice of that and make a recommendation to the council what it should be. But we've heard what you've said.
Thank you.
Okay. Thank you very much.
Thanks for your time, guys.
Safe driving home. Back to work.
You might be flying.
No, he said he couldn't get to fly.
Yeah.
That's fine.
Thanks, I'll send it through. Thank you very much. Thanks for your time, guys.
Pardon? All right, thank you. I think now we've got Kerry Community Charitable Trust, Vision Kerry Carbon Neutral Trust, and Capiro Conservation Trust. And we have Annika Whitelaw Webber. Thank you. And Melanie Miller.
Hi.
Good morning. And Inga Bremer.
Hello.
Good morning. My name's Bill Smith. I'm the chair of the panel. On my right, I've got Councillor Felicity Foy, who's also a hearing commissioner. And on my left, I've got Alan Watton, who's also a hearing commissioner. So just so you're aware, our job is to consider the submissions to the district plan and the evidence that is presented in and make a recommendation to the council. So we have read your original submission. We've read the Section 94A report from the staff on various topics. And now we're hearing from the people who want to give evidence. So if we have any questions, so I'll leave it open to you.
Kia ora, I'm Anika from our Kirikiri Community Charitable Trust.
I'm going to start first, and my bit is on signage, if that's okay. So I'm just going to share my screen.
Yep.
Okay. So I thought with signage, it's quite a visual topic. So I thought I'd just share some photos of some existing signage issues that we have around and the proliferation of signs. Because I'm not sure if you're also local and see the area, but we are known in Kirikiri and Waipapa for excessive signage. So I just thought I'd show you some examples of what we commonly see, and this is only a few of many.
Okay, Anika, can I just, when you get chance, could you email that copy of that?
She has it, it's online. I just.
Okay, carry on. You will get given a copy of what you present.
Okay, all right. So hopefully it's up on screen.
Yes, it is on screen,
Okay,
thank you.
perfect. So probably one of the biggest issues, and we had in our submission, and we did read the reply, was around the third-party signs. So business signs within certain zones that are not related to the location itself. So these are some examples of what we see common in and around. This one is out at Waipapa, where we have many different business signs on board at a business location that are unrelated. And what we do find is there's a bit of a copycat thing that happens. We have some that will just erect signs anywhere, and then other people will go, oh, they're doing it, and so we'll do it. And so we see this proliferation of signage around the area. Often on roundabouts, we see along fences, third-party signs. These are some examples here that you can see. Often on residential fences, this one here, you know, a wool caveat. Some of them are on a state highway, so of course they have different rules, but the outcomes are the same across both the local roads and the state highways. This is another retailer who gets paid to have a proliferation of third-party signs. This here is Kirikiri Road, so it's a road that gets used often. This here was our key strategic entranceway to Kirikiri until the community group, our Kirikiri, got involved, and we upgraded or enhanced the state highway, so we were able to get rid of some of these signs. This one here is Kirikiri Road. In this case, their signage is actually facing inwards to the business. Not on the outside, so I don't know if there was a resource consent or what, but these are signage that faces into the business, so you can't actually see it from the state highway, so it looks a lot tidier from Kirikiri Road, so it does look a lot tidier. But this is Kirikiri Road, so this is their business sign, and this is billboard. I presume probably get paid and hire out this, which we see very, very common in Kirikiri and Waipapa. This here again is just a proliferation of people putting signs up wherever they want. And some of these businesses haven't actually existed for 2, 3, 4 years, but they're still there. The photo at the bottom is a roundabout again, Whanus District Road. At one point there was 30 plus signs just being put up by all sorts of people, businesses and community event signs, which you have a section for event signs, which we've read and we've put in our submission around. And so this has now been taken down through complaints to council, but they were out there for a very, very, very long time, non-compliant, not being monitored until the community has to put a lot of effort and a lot of communication in with council to remove those signs. Nearly there, hopefully. Oh, this one here is petrol stations all along council roads. One petrol station did it, and now all 3 petrol stations have all third-party business signs, all seen from the main roads. So it just is getting worse and worse and worse and worse. Every week that goes by, there's more signs that are going up. This here is this very busy roundabout on a council road, signage all along here, all third-party signs. They all pay to be along here to this residential rental property, residential property here. And you can just see for this example down below, it starts off with 1 or 2, and then we end up with, 10, 15, 20 within a matter of weeks. These are billboards. We have probably, I think I counted maybe 8 to 10 large scale billboards, more and more getting installed as the weeks go by. All third-party businesses on council roads. Here's another one here, although I think that is the business itself, the location, which is why I didn't circle it. But yeah, it's a bit of a free-for-all in terms of signage. I think I'm nearly to the end of the photos. This one here is lovely. This is Waipapa. I'm not sure if this is State Highway or the council road that runs along here, but again, we put this in our submission. This is on a piece of land. I don't know if it's got resource consent for all these, but the businesses aren't actually located there. But we do understand, that it is important to market your business. And a lot of those businesses are down the road. But we would have thought that this should have gone through some sort of resource consent with conditions on how aesthetically that should look, which is one of our submissions around having them on a nice tidy hoarding, so it doesn't look like this, which is again a common occurrence. So that's a real key area or key concern that we have. This is much about the rules as it is also about monitoring and compliance, which obviously is not your area. That's council operational matter. But if you can't enforce or you can't monitor, then we need to keep the rules very strict and very basic, because there is a lot of, if it's too complicated, different zoning, different rules, and it's not being monitored, people are just going to do whatever they want. And a lot of the time, these are, a lot of them are, there's recidivist businesses. These are up to sort of one business that might have 8 signs around the place. And they're often, whether it be tradies or people who can just install the signs themselves. They've got a hammer and pieces of wood and they can put the sign up wherever they want themselves. So we're really passionate about tidying up the area with all these signage. We have mixed use, or the introduction of mixed use signs, which, have elements of residential in the business. We need to increase civic pride here. So yeah, really passionate about tightening all this up, making it very basic, and having rules that are easy to follow and easy to be enforced. So yeah, basically sort of covered off that. There's so many different forms of marketing now, particularly online, that the need for all of this signage everywhere is really unnecessary. So we want to reduce the visual clutter. We want to reintroduce some civic pride. And as our population increases, because we are one of the fastest growing areas in Kirikiri, we are of course going to be losing some of our natural assets. And we can see that around where my business operates. So it's really important that we protect the aesthetics of the area and have a really great, good looking place to live and work. So I think you can see that on screen. If you want to add, more than welcome to, ladies. So the main thing is limiting the signage to the location or the business that is at that location. No third-party signs in any zones. And if they do want to, then it needs to go through a good resource consent process where the signage, the design, the area is all considered. And one concern we do have about the resource consent being approved is the outcome to other people and what they see. They might see these signs being erected that may have a resource consent, but they don't know that. And so they merely copycat and, you know, put their signs up because other people have done. And that's really what has happened over the last 10 years. I can probably cover off. Event signs, we did read that I think the planner believed that decreasing the weeks before and after the event was a good thing. We raised that in our submissions because last year there was some large scale event signs that had been up, or the event was in November and they were up from about March onwards. Obviously it wasn't compliant even with the existing rules, but of course it wasn't enforced or monitored either. And of course we're community groups, so we have event signs as well. So, you know, we believe it should be reduced as to how long you can have those event signs up, because there are a lot of events and they are increasing, just to help with the accumulation or proliferation of signage. So yeah, really the main things is around those third party business signs. And when there is a significant amount of signage, even for its business itself, is making sure it's tidy and it's aesthetically meets the needs of the community. Yeah. Anything else?
That it? Have you finished?
Yeah.
Okay, I'll just ask if my colleagues have got any questions.
Yeah, no, I think it's pretty clear. I think the submission is pretty clear what sort of things.
It's always very good to have the photographs.
Yeah, no problems.
Just, I guess, more of a statement, just saying that the query about the third party signage and having rules in district plans, which we have a rule now about the activity relating to the site, but it may not be an enforcement role for the district plan, but what the policy planners are supposed to do is they're supposed to look at the effectiveness of the plan and monitor that. I'm not sure if there's any feedback from my same question the other day from the staff about that.
It seems to me, through the chair, that when complaints are made, the issues are resolved, albeit in a bit of a time lag. It seems to me that there is a process by which the provisions are enforced.
Most of this is an enforcement issue once.
There's substantial differences between proposed plan and provisions in the operative district plan.
Can you hear?
Yeah, I'm just turning it up a little bit. We missed it, but
Okay.
carry on. Sorry.
So there's substantial differences in terms of the number of signs, sign area, and actually the introduction of third party signs, for example. I think in terms of the way we look at third party signs, I think you've got essentially a bunch of guerrilla signs that occur in public places versus advertising of other businesses in commercial locations as a third party signs. I sort of see them as two distinct issues. And certainly it would be uncommon.
Wait a minute.
It would certainly be uncommon to have, in my experience, commercial zones that don't actually allow third-party advertising across New Zealand. In my view, it's actually quite a conservative approach that's been notified in the proposed district plan. I don't recall, even in places like high amenity towns like Greytown, for example, that there would be a limit off the top of my head recollection that it would be that level of stringency. Regardless, it is in there and provided for. But essentially every third-party sign that's provided for would require resource consent in the proposed district.
Okay.
Just like in the plan at the moment, there are RDAs at the moment, is that right? Third party signs.
In the in the current plan,
In the proposed
in the
plan.
proposed plan, my recollection is it's discretionary in the light industrial and restricted discretionary in the mixed use zone.
Yeah. So what are the RDA assessment criteria? Sorry to put you on the spot on that, but I just wonder what would be the restricted discretionary activity assessment criteria for a sign?
So the extent and effect of non-compliance with any relevant infringed standard, which is like helpful in terms of a third-party sign. Impact on character and amenity values of the surrounding area, whether the sign contributes to visual clutter, including the impact on the built form of the immediate and surrounding area, whether the sign contributes to the community well-being, whether the sign addresses traffic safety, including motorists, cyclists, and pedestrians, whether there is a functional need for the sign to be located. And I would assume that that means, and it probably needs some additional words, I would think. It's probably an incomplete assessment criteria. Whether the sign results in consolidation of signage, which is a valid point, and any adverse cumulative effects.
So it's pretty comprehensive.
Very comprehensive.
Carry on.
And I was just going to ask, so for example, this signage here, which is on a business premises, these signage here, which is on a business premises.
You're
and-
not, we can't
see.
we can't see at the moment.
Oh, sorry. Okay. I thought I'd shared it. Can you see now?
Yeah. Thank you.
Okay. So these signs here are on a business premises.
Right.
These are on a business premises. And of course, these petrol station ones are on a business premises. Are you saying that resource consent has been obtained for these? Or are you saying these are guerrilla, like people just putting signs up or businesses putting signs up? Like if that was to go through council, I mean, it's hard. We don't even know if there's a resource consent. I mean, we're not going to go around and.
At this stage, we haven't got an answer to that, right? Because the staff would have to go away and research every site. And what they're saying is that it's more of an enforcement issue. And maybe there hasn't been enforced. So,
Mr. Chair, look, I think there's no current provisions as far as I can recall in the operative district plan related to third-party signs. It's an introduction as part of the PDP. So those signs wouldn't be controlled by this rule and won't be until decisions are made May 2026.
so there's no,
They'd have existing use rights potentially if they comply.
well, only if they comply, and then that again is some. So the third-party signage is a new thing in the proposed district plan. You're
Not
aware?
for state highways. The staff haven't clarified that yet. And those sites are on state highways.
So we can't, we can't answer you today whether those signs are legal or not legal, okay? They may well be, they may not be. But if we're listening to your submission on the proposed district plan, and any provisions we put in will then have to be enforced by the appropriate staff if we decide to go down that way.
Similarly, Mr. Chair, like there's a matrix of rules that apply. It's not just about third-party signs. There's a number of signs,
Yep.
there's sites of signs. Whether a sign's a third-party sign is one of the matrix of rules that would apply.
Chair.
Wait a minute, we've got, I'm just going, one of the officers is going to ask.
I'm not going to get into particular detail, but I just wanted to highlight that signage has been a very complicated issue for council over the years. It is challenging at times from a monitoring perspective, and I just wanted to highlight that it has been a very challenging situation, especially on sites that have very high profile in terms of our roading network. We do indeed struggle with that in our district.
Okay.
And I suppose that's part of our aspect. If monitoring and compliance is very difficult, if you make the rules complicated and different tiers and maybe this, but maybe not that, but maybe, numbers of this and then not that, you're just making the job very, very difficult for people to follow and for you to monitor. So to us, no third-party signs in those zones unless it's a resource consent, and then you go through that process. Because at the moment, everyone's just doing whatever they want.
Well, that's why we're sitting here hearing the evidence,
Yeah.
because we may decide that, but that's why we're hearing the evidence.
Yeah.
Or we may recommend that the council adopt that, but that's the thing we've got to consider after we've heard all the evidence.
Yeah.
Okay, anything else on signage, or is that it?
That's it from us.
Okay, thank you very much. So who Who we're going to hear from next?
And go to you next.
I'll be here to come forward.
Thank you.
Who we're hearing from, sorry?
Pardon?
Who are we hearing from now?
Yeah, hi, kia ora, commissioners. My name is Inge Bremer. I'm speaking on behalf of Vision Kerry Kerry and Carbon Neutral Trust about the GMO and GE issues.
Can I just ask you, have you read the Section 42A report on the GMO?
Yes, I've read it, not in detail, but I have read it, scanned it.
So you understand the recommendation from the officers basically to adopt almost what was put out for consideration?
Yes, Mrs. Smith, I do understand that, and I'm very
Okay.
happy about it.
Okay, that's all right, thank you.
Okay. So I would like to present that we firmly support the Council's current precautionary approach, which prohibits the release of any genetically modified organisms, as stated in the overview of the PDP GMO chapter. We seek to retain the chapter on GMOs as notified without amendments. This approach reflects the long-standing stance of both the Farnborough District Council and other councils. For example, Hastings, Bay of Plenty, Nelson, Auckland, and Wellington. They prioritize their region's biosecurity, agriculture integrity, international market positioning, and the precautionary approach. This stance is crucial, not only to protect the environment, but also to ensure that our local economy remains resilient and competitive on the global stage. There's a bit about justification for precautionary approach, which prohibits the GMO releases. For 21 years now, since 2003, the FNDC has been a member of the Northland Auckland Inter-Council Working Party on GMO risks evaluation and management options. 3 major reports commissioned by the Northland Auckland Working Party have outlined the risks associated with outdoor GMO trials and releases. They emphasize the need for stringent risk management. The FNDC's position on GMOs aligns with the recommendations from these reports. They call for a cautious approach to GMO use to prevent possible damage to the environment and to the economy. The findings from the Northland Auckland Inter-Council Working Party highlight significant deficiencies in the national regulatory framework for GMOs, specifically within the Hazardous Substances and New Organisms Act. These deficiencies include inadequate liability provision and the absence of a mandatory requirement for the Environmental Protection Authority to adopt a precautionary approach to outdoor GE and GMO applications. FNDC's precautionary approach, which prohibits the release of GMOs, is a responsible and necessary action to create an additional layer of protection against the risks associated with outdoor GMO experiments, with field trials, conditional releases, and full releases. This position also aligns with the view of the majority of the district's ratepayers and residents. They have consistently voiced their preference for maintaining a GMO-free status in our region. This perspective aligns with the stance of other councils that have opted for more restrictive GMO regulations to safeguard their region's biosecurity and economic interests. Briefly about deficiency in national monitoring. The historical evidence has shown a number of failures by the central government regulator to adequately manage and mainly monitor outdoor GMO field trials. For example, Plant and Food Research GE Brassica trial was insufficiently monitored by both the Ministry for Primary Industries and the EPA. Such lapses underscore the need for local councils to step in and safeguard their communities by imposing their own precautionary measures to mitigate these risks. The inadequacies of national framework justify the FNDC's proactive stance in protecting our local economy and biosecurity. The responsible action of maintaining precautionary and prohibitive measures serves not only to shield existing GMO-free producers, but also to safeguard our indigenous biodiversity, our food sovereignty, and our cultural values. The value of our biosecurity cannot be overstated, as it underpins the economic sustainability of our farming sector, including conventional farming, integrated pest management, and organic producers. About the Council's legal right to maintain precautionary policies on GMOs, the Environment Court, the High Court, and the Court of Appeal have consistently upheld the right of local councils to regulate GMOs under the Resource Management Act. Decisions from these courts confirm that local authorities can establish policies that impose greater levels of control than those set by the EPA, emphasizing the responsibility of councils to protect the environmental and economic well-being of their communities. This legal standing supports FNDC's precautionary approach and strengthens the argument for retaining these provisions in the proposed district plan. The legal precedents support FNDC's position in the PDP and strengthens the case for keeping these GMO provisions intact. The panel should please consider that local councils have both the right and responsibility to enact policies that reflect the unique values of environment and environmental conditions and the market realities of their district. About support for GMO-free position by iwi and Hapu, various iwi and Hapu in this region, such as Ngāti Rangi and Ngāti Rehia, strongly support a GMO-free stance, citing concerns about the potential impact of genetic engineering on native species and ecosystems. Their submissions reflect a desire to exercise kaitiakitanga over their lands and water resources, reinforcing the cultural and environmental case against the use of GMO in this district. About concerns with GMO use in pest control, an emerging issue in the GMO debate involves the proposed use of genetic engineering for pest control, which raises significant questions about its efficacy and potential unintended consequences. While GMO technology is often presented as a solution to pest issues, there are concerns about their long-term ecological impact and the risks of introducing genetically modified species into the environment. This approach could lead to irreversible changes in ecosystems, potentially creating new problems rather than solving.
Frozen.
Are you there?
This happened at hearing 5.
You there, Ms. Bremer?
I'm Nick.
Must be wondering. Oh, you're listening to them. We don't remember paying attention either.
Yeah, I think it's our internet.
I mean, should have got the statement because she's reading it anyway, so. Are you there, Miss Bremer? Oh. It is.
Kick her out and then bring her back up.
Remember last time?
No, it wasn't.
Timmy, they had to change room. Oh, yeah, they go. They've gone, like, this happened for hearing 5, they had to go and move rooms, I think. The internet.
But she's reading the statement we've got.
Anyway, yeah, we've got the statement anyway, so.
Sort of a heck, one of the light.
There's one.
Right. If she's finished reading it, we can just tell her we.
It was still awkward.
Oh, well, yeah, they'll,
Will she still be reading?
Anika didn't answer.
We'll just pretend we never, she
It's
never
actually-
went.
Her name is,
Hearings panel's gone to lunch.
I think you did. I think you did. Yesterday. Yeah.
Okay, wasn't even sitting down, she's coming, oh, maybe she.
it was me walking back in.
Yeah. Gonna have to switch it off to it.
Oh, yeah, sorry, Anika's online system has crashed again, we're trying to reconnect.
Just tell her that we've got a statement, so. We'll read her statement and the other statement. We can't get back online.
Something like that.
General,
Yeah, we've got an.
general assessment criteria. Right?
We ended up putting. Quite a lot. Updated.
Okay.
And then, yeah, there was a way to.
So I said we do have your statement, so they're ready.
So that's good. That's good. Take notes. Yep, so it's just-
I'll just pull up on.
Hello there, how are you?
Oh, cool. Yeah, we're back. Here's the camera. Oh, okay. As I was talking about pest control, the system didn't want to hear that. Okay, so I was saying that the point is definitely avoiding new problems while trying to solve existing ones. But the interesting part here, I think, is now about the growth of non-GMO in the global markets. In the evolving global market, there is a growing trend towards stricter regulations and increasing consumer demand for non-GMO products. Fortune Business Insights, that's a 2024 report, reports that the global non-GMO food market size was $740 billion in 23 and is projected to grow 20% from 895 in 2024, then 12% per annum to $2,003 billion by 2032. That is really a considerable growth rate for the next 8 years. So the GMO-free policies of major food corporations favor non-GMO products. The major corporations like Nestlé, Danone, and General Mills have adopted stringent non-GMO policies to align with consumer preferences and market demands. These policies significantly influence agricultural practices worldwide. They impact supply chains and set high standards for non-GMO ingredients. For example, Nestlé, one of Fonterra's largest customers, requires strict non-GMO standards for their supply chains.
Has your microphone moved, Miss Kramer?
Pardon, yeah?
You're getting faint. Just make sure you speak into the microphone, please.
Yes.
Okay, that's all right. Thank you.
Okay. So I'm talking about Nestlé, one of Fonterra's largest customers. They've been focusing on expanding non-GMO ingredients to meet customer demand for natural and organic products. The company's efforts are part of a broader strategy to maintain transparency and sustainability across its supply chains, one of which is in New Zealand. The company states that Nestlé Oceania requires suppliers to demonstrate that only non-GM ingredients are supplied. Danone. This global dairy and nutrition company has prioritized non-GMO ingredients in its supply chain, particularly in its US brands like Danone, Oikos, and Danimals. The company emphasizes sustainable agriculture and non-GMO practice. General Mills, the company, has committed to using non-GMO ingredients for some of its popular brands. Cheerios might be well known. Unilever. Unilever is increasingly focusing on non-GMO options in its food products to meet consumer demand for natural ingredients. Although not entirely non-GMO, Unilever's approach is geared towards offering more transparency and sustainability in its product offerings, in line with global trends towards cleaner, more natural food sources. In conclusion, we strongly support the Council's precautionary approach, which prohibits the release of GMOs. We seek to retain the chapter on GMOs as not notified without amendments. Given the well-documented deficiencies in national GMO regulation, the repeated failures of central monitoring bodies, and the significant market risks associated with GMO adoption, it is crucial that our local policies continue to take a precautionary approach to the protection of our environment, our economy, and our community values. The FNDC's precautionary stance not only aligns with the best practices identified by the Northland Auckland Intercouncil Working Party, but also secures the future of our GMO-free primary producers, ensuring that they continue to thrive in a global market that increasingly values natural and unmodified products. Thank you.
Thank you very much. I'll just ask if any of my colleagues have got any questions.
Yeah.
It's a comprehensive statement. Thanks.
I think your statement that you produced.
Okay, so I'll hand you over to Dr. Melanie Miller.
Okay, thank you. Thank you. Hello there. We've got your statement here. When you're ready.
Thank you. My name is Melanie Miller, speaking on behalf of Vision Kerry Kerry, Urban Neutral Trust and Kapira Conservation Trust on the light chapter. So our comments address provisions relating to Indigenous wildlife, light pollution affecting night skies and energy efficiency. And I'd like to clarify that we're not seeking standards for dark sky reserves. We are just seeking general, responsible, good practice to reduce light pollution. And we also recognise the cultural values to Maori, dark sky and night skies. So firstly, some comments on the Section 42 Officers' Amendments. I should mention we sent a paper through to Alicia Kate this morning by email, so you may have that online, I hope, in front of you.
You have the paper. We have the paper in front of us.
Okay, you do, good. Sorry, the sound quality is really poor. I apologise.
Right, okay.
So in the overview, we do support the Section 42 report's new text about night sky values, and the same for the note, the new note about pollution guidelines for wildlife. But we'd like to propose using an updated web link for those CMS guidelines on wildlife. That's actually on the convention's website, and that's shown in our statement. We also propose adding a guideline about responsible lighting for night skies, and there is one available, often recommended by groups, by the International Dark Sky Association. They have principles for responsible outdoor lighting. This is not about making a dark sky reserve, it's about just general good practice for avoiding or minimizing light pollution. And again, we've given the web link for that in our paper. We also support the Section 42 report's new clauses. There are 3 of them about Indigenous fauna in Light P2 and Light S1. We do support the retention of the notified text relating to wildlife, enjoyment and views of the night sky, intrinsically dark landscapes, and protecting amenity values and the environment. However, we are concerned that the clauses above don't need to be considered when activities meet the permitted activity rule and standard, light R1 and light RS1. And this suggests that a number of developments would not need to consider the general factors such as nocturnal wildlife or minimizing light pollution to the night sky. We also remain very concerned that the lighting chapter has not referred to energy efficiency. We would therefore seek to add another clause in Light Rule 1, R1, and that would be that the lighting design has considered the following matters. That's energy efficient design, the guidelines on wildlife as specified in the new overview note, and guidelines on responsible, responsible outdoor lighting That's the night skies recommendation, which we have proposed should be added in the note. So what are our reasons? Firstly, if we look at the effects of outdoor lighting on native wildlife, it's well known that there are nocturnal species such as kiwi, some migratory birds, lizards, bats, a number of them are at risk and sensitive to artificial light at night. So the adverse effects of light, this can include things like disorientation, changes in feeding behavior, and even reproduction, even have effects on reproduction and growth. You may be aware that New Zealand is actually the seabird capital of the world. We probably have more seabird species here than any other country. However, a lot of them are at risk or threatened. Seabirds in particular, as one example, can be disorientated by bright lights in coastal areas, but also inland. And simple good practice in designing lighting for new developments, wherever they are, would help to reduce this problem, not just for seabirds, but for all nocturnal species in general. In high density kiwi areas, for example, Kiwi Coast has recommended avoiding bright lighting and using a warm colour light towards amber or red wavelengths, avoiding white and blue. And this is a general recommendation that suits many species, not all, but many of them. Yes.
Sorry, we just had a connection issue, but we're okay now.
Sorry, I'm just going to try and share my screen. I don't know if this is going to work.
It should be able to, like, you have access to share it.
Okay.
You want to continue on?
Is it something that I've got that you'd like me to share?
I'll just see if I can find, oh, sorry, here it is. So in the paper that we sent, there is a colour temperature chart, just to explain what we're talking about.
Yeah, but what is probably better, we have got your paper here.
Okay.
It's probably better for you to do is focus on what you would like us to do.
Okay, fine. So basically, the wildlife friendly lights generally avoid the white or blue end of the scale that you can see in front of you. And wildlife is generally favoured, has less impact if lights are down towards the left side of the scale, which is the warmer or amber around, and the general recommendation is for warm LEDs, for example, around 2,700 Kelvin or less. That's at the left end of the scale. And interestingly, the responsible lighting guidelines are actually very similar for both wildlife and preserving dark skies. So the main principles are to shield or direct the light so it falls only in the area that needs light, to use less bright light where possible, and to avoid light with the blue or white wavelengths and aim for the warmer wavelengths. These are relatively simple best practice guidelines that have been produced both for wildlife and for darker skies, and just minimizing light pollution where possible, just as general responsible lighting design practices. These are simple. It's not a difficult thing to do. And some of them even save cost. Here's a summary of a visual summary of some of the same information to only add light for specific purposes, light only the area intended, use the lowest intensity, use dark colored surfaces if possible, and avoid the blue wavelengths in particular. Again, another example, the International Dark Sky Principles for Responsible Outdoor Lighting These are simple requirements that many people could follow quite easily. So we consider that it would make sense to actually require people to consider these guidelines, these types of guidelines, as part of Light Rule 1, rather than just not referring to it at all. So there is a second major issue for our organisations, which is on energy efficiency for outdoor lighting. There are statements in some of the standard lighting design manuals, statements relating to energy efficiency that have not been reflected in the PDP chapter. For example, the Northland Transportation Alliance Design Manual for Street Lighting states that in regards to energy efficiency, the installation must be designed for economic use of energy, and that all new or replacement luminaires, basically bulbs, must be LED. This refers to street lighting. And Auckland Transport Street Lighting Manual standards for roads and amenity lighting has the same phrases. And we think at the moment the PDP light chapter is inconsistent and should actually contain and state these similar principles, which I've just read out to you. We also think, as stated, that the PDP should require consideration of energy efficient design. And what are our reasons for this? It's that the RMA actually requires this. This is not something we've made up. As you would know, the council is required to have particular regard to the efficiency of the end use of energy. And especially when preparing a plan, councils are required to have regard to the National Emissions Reduction Plan. And that contains a number of areas relating to emissions reduction and includes the comment that the planning system can promote low emissions development, that reduce energy demand, and when we use less energy, this is very important because we can delay the need for new electricity infrastructure in terms of whole new generation plants, which is very expensive nationally. So the Regional Development Guidelines in the RPS Appendix 2 also require that new subdivision use and development should adopt, where appropriate, sustainable design technologies such as incorporation of energy efficient design, low energy street lighting. And we don't see this in the PDP at presently written. We notice also that there are some existing energy efficiency provisions in the existing operative district plan, and I've listed them, some examples in the yellow box, box 1, such as 13.16, the adoption of energy efficiency technologies will need to be considered in all new subdivisions and related development. However, the PDP generally lacks energy efficiency provisions, and we find it quite extraordinary that it barely mentions the need to consider or promote energy efficient design. When we did a search on the PDP text, we searched for efficiency and efficient, and we found only 2 clauses that mention energy efficiency in the entire PDP. And they were just in 2 particular zones. But this sort of wording needs to be, that's present for those 2 zones, needs to be included throughout. So I will end there, and I would like to thank you very much for your patience with regard to our internet connection problems. And we'll try and find a different location, I think, for our next hearing meeting. Thank you for your time.
Don't worry about that. It's very good that you've produced a statement, because we can reread it again and take on board exactly what you've said in writing. Okay, I'll just ask if anybody's got any questions.
Very comprehensive.
No, it's useful to have just a written statement, thanks.
Between you three of you, have you got anything else you want to tell us?
There was actually, there was one other point actually that I forgot to mention. The Section 42 report did consider that our comments about more information on lighting should not be taken on board because of cost issues. But I think it's important to note that the National Energy Efficiency Body, ECA, does say that LED bulbs use up to 85% less electricity than traditional bulbs. And in terms of household, LEDs can save more than $100 per year in electricity costs. This was a few years ago before the costs went up. I couldn't find data for roading lighting. However, I think we can deduce that when a developer vests a new road they have built in the council, it will be the council who has to pay the electricity costs for street lights forevermore. And so any annual cost savings in electricity will really add up over time from having much more energy efficient lighting for street lights and public community areas and so on. I think that was the main. As well as reducing climate emissions, absolutely.
That's okay. Thank you. I'll just ask the staff if we've got any thoughts that we want to raise. Anything? No. Okay. Okay. Everything's clear. Thank you for your presentation. Thank you to the other two ladies.
Thank you very much.
Thank you. Goodbye.
Thank you for your time.
Wrap up with that kind of gear. Turuki whakataha, turuki whakataha, whakaere te wānanga, ia wātia, aera, kua wātia, huie tākei. I will stop recording and leave the meeting.